There's no doubt that winters in New York make it tougher to get around. But harsh weather can become more than just an annoyance if you've fallen while trying to get to work, running errands, or just out walking the dog. Your slip and fall accident may have landed you in a doctor's office, the emergency room, or even laid up in a hospital for days. If you've been injured after falling on ice, you may be entitled to compensation. That's because the law recognizes that while cleaning up after bad weather can be a challenge, landowners have a responsibility to keep their property safe for others. Who is liable for a slip and fall accident on ice? When working with a client who comes to us after falling on snow or ice, we want to determine who should be the object of an insurance claim or lawsuit. The person or entity responsible for a slip and fall accident on ice will be whoever is responsible for the safety of the premises where the accident took place. This might be a public entity such as a city, town, or village, a commercial property owner, a commercial property lessee, a third-party snow removal company, a private non-commercial property owner such as a homeowner, or your employer. Figuring out who's responsible is not always straightforward. It's not always clear whether a property is privately or publicly owned. Also, a property may have multiple parties who are responsible for its maintenance, making it unclear who is responsible, specifically for ice and snow removal. And it's our job to identify who's liable. When is someone responsible for a slip and fall accident on ice? Liability for a slip and fall accident on ice depends on whether the party responsible for the safety of the property was negligent. Negligence is a legal concept which roughly means careless. Essentially, a property owner is liable if they knew that a dangerous condition existed, or should have known that it existed, failed to properly address it, and that dangerous condition caused someone who was lawfully on the property to be injured. So to build a strong case, we want to prove these three things. Now, the law isn't looking for property owners to be perfect. It simply wants a property owner to do what is reasonable. But determining what's reasonable is typically the most challenging aspect of these types of cases. Especially in areas that tend to get a lot of snow, the responsible party can't reasonably be expected to know about and/or clear snow the second it falls. Proving your case in a slip and fall accident that's caused by an icy or snow-covered surface will require some type of investigation by your legal team. At Rosenblum Law, our dedicated team of attorneys has decades of experience building and winning personal injury cases that get our clients the compensation they need to cover their expenses and get on with their lives. Contact us today for a free, no-obligation consultation.